Wright, my partner from Schindler's Attorneys, Ian Fleming from Engaged, Peter Gordon, also from Engaged, and Francois Ackerman from the IQ Business Group. We are not going to go through the act section by section. We've already done that, and we've posted the video on the Schindler's website. So if you want to go through it meticulously and have a commentary in relation to each section, it's there. What we're going to do today is we're going to have a Q&A session with the participants. I'll be hosting the session, and the participants will be, I'll direct questions to the participants, but I really ask that you do the same. There are features to ask questions on this webinar. You can pose questions anonymously, but importantly, you can pose questions that are specific to your industry and have them answered by experts. We are having a webinar which ought to be this Friday. We're not sure because this Friday is Good Friday, so we're just checking as to whether it would be appropriate. But otherwise, it'll be on Tuesday, and it's in relation to the hospitality business with a particular emphasis on restaurants. I see we've been joined by Lisa Marie Hussey. Lisa's also a partner at Schindler's, and Artisha from the IQ Business Group. So we have a full house of panelists today. Again, let me reiterate, please at least think of one question to ask if you can, because it makes these sessions far, far more fruitful. So I'm going to kick off, and I'm going to ask Ian just to give us an idea of when a company ought to go into business rescue. What are the circumstances where a company ought to go into business rescue as opposed to being financially distressed and not going into business rescue? Ian?
Thank you, Maurice. So a company needs to, if a company is in financial distress, in other words, either if it is factually insolvent, or if it sees itself being factually insolvent within the next 6 months, or if it sees itself not being able to pay its debts in the normal course of business in the next 6 months, then it needs to put it needs to put a vote to the board as to whether the company goes into business rescue or not. So yes, the test is financial distress, and there has to be a reasonable prospect of returning the company to a solvent going concern, or giving creditors a better return in liquidation. Those are the requirements for a company to be put into business rescue. If the board takes the decision not to go into business rescue, then in terms of section 1297 of the Companies Act, they need to notify all affected persons of the company as to affected persons being creditors, shareholders and employees of the company, of the fact that the company is in financial distress and the reasons that they are not going into business rescue. Maurice, let me just carry on. And the reason why the COBRA ecosystem has been created is for companies that are in financial distress that may or may not know whether to go into business rescue or not. Our aim in the COBRA ecosystem is to keep them out of business rescue as long as possible, only to use business rescue if we really need the protection that business rescue offers.
Yeah, and I think that's an important aspect for the audience to realize, is that ordinarily you'd have to vote and put the company into business rescue in most circumstances. The idea is to avoid a business rescue in circumstances where you are financially distressed. So if you are financially distressed, how does one avoid a business rescue? By getting into the COBRA ecosystem, so we can negotiate and mediate, in fact, with your creditors and in turn their creditors. Just on financially distressed, I was distracted just with a question that was posed. Have you dealt with the meaning of financially distressed? Yeah.
Yes, I have.
Okay, brilliant.
Meaning of financial distress. Let me just, maybe I can just repeat it very quickly.
Yeah.
If you are factually insolvent, in other words, if your liabilities exceed your assets, if within the next 6 months you're likely to be factually insolvent, and if you are commercially insolvent, in other words, you can't pay your debts in the normal course of business, or within the next 6 months you see it unlikely that you'll be able to pay your debts in the normal course of business, that is the definition of financial distress.
Okay, now the purpose of business rescue, Peter, with specific emphasis on the moratorium?
Sorry, Maurice. Yes, the moratorium is absolutely. Before I go into that, and just to clarify something that Ian's just said, I mean, interestingly enough, the Companies Act generally for businesses trading in insolvent circumstances is classed as a company that has an insolvent balance sheet, liabilities exceed assets, and it's not going to be able to pay its debts as and when they fall due, or not not able to pay its debts as and when they fall due in the next 12 months. Directors are very cautious of that because in terms of Section 22, they can be held to be trading recklessly if that is the situation. Business Rescue Chapter 6 has made it a lot easier. All it says essentially is if you cannot pay your liabilities when they fall due in the next 6 months, so it shortened that period. Because, you know, as Ian was saying, I mean, if you can't pay your debts, but very often, and it's a classic, you have a solvent balance sheet, but you cannot pay your debts. And if that is the case, then you qualify for business rescue. So to the question, what does it do? It gives you an absolute steel blanket around you. There can be no litigation brought against the company, no legal actions whatsoever. And the important thing there is it's not only about recovery of debt. The company, not the directors, or shareholders. The company is fully protected within the law. So nobody can bring a case against the company. And you often find that there are other issues that aren't necessary recovery of debt. There might be disputes pending on issues of ownership or transfer of ownership or anything like that, or, you know, malfeasance. If there is that sort of thing, a person cannot bring an action against the company. So what it does for the period of business rescue, it absolutely protects the company and allows the company to then operate free of the challenge of legal issues and try and recover the business. When I say free of legal issues, obviously if there's any wrongdoing by the practitioner or the directors, anybody can apply to court to have the business rescue turned aside or to have the business rescue practitioner replaced. So it's not sacrosanct in that sense, rightly so. People must operate, all practitioners and directors must operate in the law. So that's the protection. I don't know, Maurice, do you want me to go on about how the directors operate with the...
Yeah, I just want to add, just coupled with the protection, what's important is the suspension of leases. I think if you can just mention that and its importance when it comes to the appointment of business rescue practitioner and the notices that have to go out, Peter.
Sure. One thing that is often missed, because these are, obviously it's a legal process driven by time limits and forms that have to go into the regulator, which in business rescue is CRPC. One of the things that often is missed is that every company will have ongoing contracts, whether that's your lease, your hire purchase for your car, your operating lease over the photocopier, et cetera. You might have contracts with your IT suppliers, MTN, Vodacom, et cetera. Equally, bank loans, those are ongoing commitments. So the important thing there for the practitioner to do is to, obviously, in terms of the act, that you have to advise all creditors that the company has gone into rescue and there are time limits for that. But importantly, a practitioner must advise everybody that's on the other side of an agreement that he is suspending the agreement. And the reason for doing that is that there's no point in going into rescue and then suddenly find you've got significant leakage out of the bank account, going to pay various obligations, which is preventing you from saving the money and using it for the essential business of keeping the company going. So that is important, but obviously once you've done that, then the negotiation starts. There's no point in advising your landlord that you're suspending his contract and then not having a negotiation with him as to how the company remains in situ. So those ongoing negotiations are quite critical to make sure that the essential suppliers can continue into the business. Obviously, if it's non-essential, the director's very fancy motor vehicle might be a negotiation with the bank to allow them to take the vehicle back or to have a reduction in monthly repayments or anything. I mean, there it's a clean sheet of paper on where one can negotiate. And certainly in the current climate, dare I say that a lot of people on the other side, i.e. the creditor, are open to negotiations, because the last thing they want to do is have yet more defaulters on their books.
Ian, can you just take us through how to place a company into business rescue?
Certainly, Maurice. It's there's a set of forms that needs to be filled out. It's not onerous at all. We typically keep it down to about 5 pages that need to be signed. Sworn affidavit, resolution by the board, and then a PI score, what we call a public interest score, as recognized by the CIPC, and then a CIPC form. It's really a quick process to complete these forms. They get, we help you to submit them. They get sent to the CIPC, and the moment they get sent to the CIPC, that company is in fact in business rescue. 5 days later, 5 business days after the company going into business rescue, it's the onus of the company to appoint a business rescue practitioner within 5 business days, and to inform all creditors of the fact that the company is in business rescue. Once the practitioner is appointed, he has 10 business days in which to hold a meeting, one meeting with creditors and another meeting with employees or employee representatives, to inform those affected persons as to whether he believes there's a reasonable prospect of returning the company to a solvent going concern, or of giving creditors a better return than they would get in liquidation. That happens 10 days after the business rescue practitioner is appointed. The timelines of business rescue are fairly tight because everything has to happen quickly. But everything in business rescue is inherently urgent. So within 10 days, the business rescue practitioner literally has to understand the business and express an opinion as to whether he believes there's a reasonable prospect. And then 25 days after being appointed, the business rescue practitioner has to present a business rescue plan for creditors to consider, and for the creditors to vote upon after another 10 days after they've had time to consider it. In practice, the publication of the business rescue plan does often get postponed for various reasons. 25 days is a very limited period of time. We always like to adhere to the 25 days in order to publish the plan, because when you do adhere to the 25 days, creditors see that you're taking the business rescue very seriously, and it's always a good way to start, to get that relationship started with in the interaction with the creditors, is to get the business rescue plan out on time. However, in cases such as SAA, there's been a complete paradigm shift in the outlook for the company as a result of COVID-19, and hence the reason why the business rescue practitioners in that instance asked for another 2-month extension, because that is the right thing to do in the event that there's a complete change in circumstances that might affect the outcome of the company. So let's just quickly, very, very quickly talk about the voting process. 10 days after the business rescue plan is published, the business rescue practitioner then calls the creditors together, and they vote on the business rescue plan as to whether the business rescue plan should be adopted or whether it should be rejected. For the plan to be adopted, it requires a majority vote of 75% of all creditors who vote and by value to have the plan passed, and it requires a 50% or a simple majority of all independent creditors, in other words, excluding directors and shareholders, loans, of creditors by value who vote for the plan to be passed.
I want to just mention there, so at the point we started off by saying, how does one put a company into business rescue? I just want to go back as to why one would put a company into business rescue, and that is just really, in our mind, in these circumstances, business rescue is only necessary if the creditors do not play ball. And they should play ball considering the circumstances that every business finds itself in, or most businesses find themselves in. So what normally happens is creditors have the bargaining power rests with them, because they're in a position to liquidate, they're in a position to take steps to enforce their claim. And when it comes to negotiating with them, they hold the shots. So if they do not cooperate, you put the company into business rescue, and that levels the playing field. Now they don't have the power. The creditors cannot lay claim to the funds. What they can do, though, is they can apply for your liquidation. So there are two ways to put a company into business rescue. The one is by way of a simple majority and director's resolution. Another one is a liquidation. If a creditor launches an application for a liquidation, at that point you cannot place the company into business rescue by way of a resolution. You have to counter apply in court for the rescue. There are a few takeaways that we really want the audience to make notes of. They relate to employees and they relate to post-commencement finance. So I'll start with post-commencement finance. And the important takeaway when it comes to that is a lot of companies we've experienced in the last 2 weeks have been putting money into the company to assist their employees to keep the money going by way of shareholder loan accounts. Now, that money, if it's put in whilst your business is not in rescue, when it comes to claiming back that money or getting repaid, you would remain a concurrent creditor. However, if you put the money in post-business rescue, you get what's known as super preference. It's known as post-commencement finance, and you enjoy a super preference. So the point I'm making is, if you are contemplating putting money into the business, rather do it by way of a business rescue to get the super preference, even if it's a case of putting the money in and then pulling it out of business rescue. So if all that's required in your mind is a cash injection of, let's say, 100,000 rands, put it in rescue. COBRA will guide you and then take it out of rescue. Business rescues can be very quick. We had a restaurant in Camps Bay that all that was required was a negotiation with the landlord, and the landlord realized that he couldn't suck blood from stone, so the landlord came to the party. The business rescue practitioner negotiated a 25% discount on the lease, and the company was taken out of rescue. So it can be quick, or it can be very complicated. If it becomes adversarial and the court applications by creditors to try and convert a business rescue into liquidation, it can become very costly and as I said, complicated. But on the question of post-commencement finance, I think let's go into more detail there, Peter, if you can take us through the concept.
Maurice, sure. It's a difficult thing to raise. It's not a liquid market in South Africa, i.e. the distressed debt market, unlike Europe and the States. So normally what one's got to do is identify potential suppliers of post-rescue finance. If the company, and Maurice, you've covered the reason for not going in, and I'm taking it now that we are in rescue. The important thing that we would do first thing is to speak to the shareholders. Shareholders are normally the source of money, as you rightly said, so if they can put it in, it comes in as super preferent. The other point to make, either pre or post on the story of the shareholders' loans, if a shareholder is going to put money into the company and has decided that it is going to be disastrous to go into rescue, and there are reasons why that might be the case, which I'll cover in a second, then remember the shareholder can take security. If there's security in the company to give the shareholder that hasn't already been taken up. Unfortunately, when companies are facing financial distress, the directors have often used up the entire asset base of the company to offer forward as security to the banks and the like. So we're now in rescue. The practitioner speaks to the shareholders. The shareholders say, sorry, we've got nothing. The thing that Ian and I always do is, second meeting we have was probably with the banks. We've advised the banks that you've advised all the creditors that the company's in rescue. That meeting is quite critical to get the bank support, not only from a PCF point of view, but virtually, all companies are operating a bank account, it goes without saying, Some are in positive territory, some negative. If you're in negative territory, i.e. an overdraft and working capital facility, then it's quite critical to get the bank to allow you to continue to use that working capital facility. Otherwise, how are you going to pay your suppliers and your staff going forward? So that is a critical step to the rescue. If the relationship with the bank has been difficult in the past, sometimes this is a difficult negotiation for the practitioner. Hence, we always say that we keep an open door to the banks and we have a very good working relationship. Thankfully, the banks have all set up specialized units to deal specifically with business rescues. So the people occupying those positions are all well versed in the law. They know their rights, they know the company's rights, and it makes life a lot easier to negotiate with them. The other people that are providing post-commencement finance that everybody always forgets is your staff. Every day that the staff work for you and haven't been paid, they are becoming creditors. They're also creditors for things such as accrued leave and bonuses, etc. So your staff are by default providing you with post-rescue finance. Then the next important one is who are the critical suppliers? Because there's no point in going into business rescue if the supply line of your essential goods into whatever your process is disappears. And so one has to have a negotiation with your suppliers. Negotiation is and flexibility is the order of the day here, because when you're in rescue, to try and jump suppliers into a competitive supplier is not the easiest thing to do. Now, what we would normally do with suppliers is try and obviously get extended facilities, but new facilities. So remember that on the day of rescue, all creditors' balances are frozen. So from a supplier's point of view, you're saying to them, yep, we agree we owe you X from the past, pre-rescue, but what we'd like to do is arrange a new facility, and for that you are preferent, and we're going to give you security for that, or we've scraped together a bit of cash and we put something on deposit. Obviously the worst situation, the worst situation is he stops supplying, but before that point is that you're having to pay COD, because that cash is king in a rescue. And if you can preserve cash as much as possible and use it for those essential things to keep the lifeblood going, then that's quite essential. There are a few people, we are in touch with one or two of them who are the biggest in the country that are looking at distressed debt. There are a couple of larger conglomerates, Bidvest springs to mind, who are quite open to buying companies out of rescue. So, you know, those people will, not that that's necessarily PCF, but it is certainly a way to solve a rescue if you can sell off parts of the business, which you're allowed to do. So it's a tricky thing, but it is certainly an early question for the practitioners to ask, because if you don't have PCF, the thing's not rescuable.
Whilst on the topic is, if you know that a business is not rescuable, is business rescue still appropriate?
Reese, it's a very, very difficult thing. As Ian pointed out, you know, within that 5-day period, the practitioner has to be appointed 5 days after the going into rescue. And that's a hell of a short period of time to come into something that you know absolutely nothing about. You'll obviously immediately call for the latest management accounts and last financial accounts, but that is not guaranteed that those figures are accurate under a rescue situation. It also doesn't give you a flavor of the viability. So obviously the preferred route is that we get involved before it goes into rescue, and if possible, and we're doing 2 at the moment, trying to keep them out of rescue for other reasons, so that you do what is in terms of the act called a pre-rescue assessment, which we're allowed to do. Bearing in mind, a practitioner can't take an appointment if he's been involved in the company for many years, because he then lacks independence, and a practitioner has to be independent. So in those pre-rescue consultative days, you're allowed to get to grips with the business, and it gives you a far better feel of whether this business is rescuable. If you're appointed and you haven't got all the information, it is one of the more difficult questions to ask yourself. You can refuse the appointment, obviously, if you think this really is just a scam and all the directors are trying to do is postpone the inevitable, and you know, you can decline the appointment. if you take the appointment and you immediately realize, immediately, I'm talking within weeks, that it isn't rescuable. I had one of these last year, a mining contractor. They told me that their liabilities were less than 20 million, and they had equipment on site that was close to that number. Within 3 weeks, creditors were suddenly closer to 100 million, and the equipment on site was south of 10 million. That's not a rescuable business. They didn't have long-term contracts. They couldn't perform under their contracts. So I then was obligated to put it into liquidation. As Ian said, that first meeting of creditors 10 days after appointment, I had the meeting and advised the creditors that I was going the liquidation route rather than rescue. And when I say I, all that means is I've got to appoint a liquidator. We're not allowed as a rescue practitioner to do the liquidation. On the other extreme, I've had a case where the balance sheet was solvent, but with a property development that was overvalued literally by 200%, and creditors were understated by 50%. It looked like a lame duck. The creditors were baying for my blood because they wanted it put into liquidation. I got a professional liquidation valuation done that allocated 10 cents in the rand to the virtually all the creditors were unsecured, to the unsecured creditors. This went into rescue in 2015. I took it out of rescue July this year. So as Ian was saying, we try our damnedest to do it as quickly as possible, but sometimes it isn't possible. And we managed to pay all the creditors with secured debentures over a period of time. So it calls for creativity. It calls for financial engineering. And I know Ian will touch it at some stage during this webinar, but one of the critical things that is for us is that the directors and or shareholders, it's a director decision, often it's the same people, but from a director's point of view, they must feel comfortable with the rescue practitioner. And I would say the critical thing there is trust, flexibility, and the point of and transparency, and the ability to work with rather than against the company. There's no point in trying to rescue something if you're working against it all the time. It's going to die on the operating table.
Peter, you mentioned that case where you put the company into liquidation, and I'm looking on the screen now at the definition. Sorry, let me just undo that. If you have a look here at the definition, you'll see it says a better return for creditors. So over here, it's not necessarily a saving of the business, it's just a better return for creditors. Can you just, well, why did you put the business into liquidation if you could have achieved a better, not salvaged the business, but achieved a better return for creditors? Why in that case did you make that decision?
Maurice, it's a good point, because as you rightly say, a rescue is not necessarily rescued to the point that it's now breathing normally and has got money in the bank account and carries on its merry way. It can be that under a rescue scenario, you've got assets that if you sell them under the auctioneer's hammer, i.e. in terms of a liquidation, you're going to get a fire sale value for them. And we all know what that means. That's rock bottom prices with the vultures circulating to pick up the scraps. In a rescue, you can sell the assets off over a period of time. Ian and I recently did one where the main asset was fiber connections, underground fiber connections. To find buyers for that under a forced sale would have been very easy, because they would have all been there trying to pick up these fairly valuable assets, but was of no use to anybody other than the people that are providing services in the data industry. What we managed to do was to do a structured wind down, which meant negotiating, and thankfully we got 3 operators keen to buy these assets, which meant we were able to push the price up to the limit, and did a structured sale, and we also accommodated the buyers. So in that scenario, we gave a far better return to the creditors than in liquidation. However, when you've got a situation where you've got 100 million of liabilities, and you've got less, and when I say less, about 6.5 million of assets, the attraction of liquidation, notwithstanding the liquidator's fees, is it's short and sharp. The liquidator takes over the application to court, assuming it's not opposed, should go through fairly smoothly. You've got a liquidator, and all he does is sell those assets, we're talking about mining contractors' assets, and if they only were 6.5 million, you can imagine there wasn't a huge number of them. To try and sell those off into a market over a period of time and get a better value than you would under liquidation is probably unlikely. You're going to come to the same point. The other important point with the liquidation, which the rescue practitioners don't have, the Chapter 6 of the Companies Act obligates a business rescue practitioner to investigate any wrongdoing. If he finds anything that the company has been or is continuing to do that is contrary to law. Now, this is a big thing for a practitioner because it's any law. It's not only the Companies Act. It's labor law. It could be Information Competitions Act, etc. The practitioner is obligated to investigate it to ascertain that the law is being broken. Obviously, what the financial effects of this are. He or she is required to instruct management to desist and cease doing whatever they have been doing, and then importantly, report it to a regulatory authority or to the authorities, I think the Act says. The authorities could be the local police station, which I think we'd all accept is not going to go very far. In the one that I talked about earlier that took me 4 years, it was a financial services company. I reported the wrongdoing to what was then the FSB, now the FSCA. So, once that reporting is done, that's the practitioner's job complete. And the reason for that is the practitioner is there to rescue the company, not necessarily to get bogged down with legal action against directors, staff, or whatever. A liquidator, on the other hand, has full rights to subpoena. In liquidation law, there's what's called a Section 417 inquiry, normally held before a retired judge. And the liquidator can subpoena anybody, all and sundry. We've had one recently where the lawyers that were helping us on this were all subpoenaed into a fairly distant part of this country. So it's a right that the practitioner doesn't have. And obviously in the realm of a subpoena and a 417 inquiry, one can dig deep into illegalities. So if there is a scenario where there's been extensive illegalities, then I think it is pertinent and where the possibility of paying a dividend vastly different under rescue versus liquidation is a bit tight, then I, as a practitioner, would certainly give it some serious thought whether liquidation is not a better route to take.
Thanks, Peter. There's a great question that's been posed that I'd like to deal with. It's by Chris. He says, if you set up a trust and the trust lends a company A money, and the company A, you're not related to them, and lends your company B, you're a director and shareholder, money. Now company B is factory insolvent. Are you an independent creditor? So what I'll do is I'll go through the Act and answering that, because it is spelled out in the Act. The starting point would be to consider what an independent creditor is defined as. You'll see here, independent creditor means a person who is a creditor of a company, but this is what is relevant, is not related to the company, a director or the practitioner, subject to subsection 2. When it comes to related, what is meant by related, we go to the definitions, and you'll see related there is when used in respect of two persons, means persons who are connected to one another in any manner contemplated in 2(1)(a) to C. And then we go to 2(1)(a)(c), and you'll see here a juristic person is related to another juristic person if either of them directly or indirectly controls the other, or the business of the other as determined is either a subsidiary or a person directly or indirectly controls each of them, or the business of each of them. So I would say you're covered there in your question because there is a company that's interposed that you don't have control over. But bear in mind that control, when it comes to trusts and companies, the courts pierce the veil quite often if they're regarded as alter egos. So in this case, if it can be demonstrated that the trusts or the company are in fact alter egos and that there is this degree of control, then it will not be regarded as an independent creditor. But from the facts that you've given to me, I think you'd certainly pass it. And that's because you say you are not a director and shareholder. Sorry, maybe I misconstrued. You're not related to the company A, and lends your company B, your director and shareholder company B. So you're not related to the company A, which ends the inquiry there. If, however, you have control because you have a proxy running the company, that's a different matter.
Maurice, from a practical point on that, yeah, I agree with you. I don't think that is a related creditor. You know, practically your non-independent creditors are normally your shareholder loans, director loans, and then intercompany loans where, you know, the company's part of a group or they two companies controlled by the same directors and or shareholders.
Yeah. What we haven't dealt with, which I'd like to move on to, which is another key takeaway, is how one deals with employees and what happens practically with employees. So I'll start off just by dealing with the law, and then I'll hand over to Ian, who'll deal with the practicalities as a business rescue practitioner, how the employees are actually dealt with. But on the law, employees enjoy the exact same rights as they enjoy outside of business rescue. So provisions such as Section 189 of the Companies Act, which relates to retrenchments, which is also applicable when it comes to unilateral variations of employment agreements, that still applies. So if you're contemplating retrenchments, you still have to consult. In terms of 189, you still have to consult on the reasons for the proposed retrenchments, the alternatives that were considered, how many retrenchments are proposed. You have to give a written notice to that effect. So that still has to apply. What we as practitioners believe has changed is we believe that the courts will be far more forgiving to employers when it comes to the procedural aspect. So in labor law, you have to deal with the substantive fairness, which means there have to be good reasons for the retrenchments, and procedural fairness, which means you followed fair procedure, which generally means, involves consulting with the employees and that consultation process being meaningful. What's changed is, in our view, the duration of the procedural fairness, that process, has been curtailed. You don't need to consult on the reasons because we all know the reasons. So there's no digging deep by the employer into whether the reasons are true or not. We're dealing with an act of God, so we know. So what practically one can do, the business rescue practitioner can meet with the employees and start consulting, but on an expedited basis, to try and get agreement with the employees to, let's say, a remission in salary or a temporary remission in salary to get you through this. Over the last couple of weeks, employees have come to the party in relation to respect of every business we've dealt with. So employees are being reasonable. They realize that they can't suck blood from stone, and they are agreeing to remissions. What we are seeing is quite a few companies are just agreeing to, let's say, a 25% reduction in salaries, which you won't know whether that's enough. You don't know what the position is going to be in 2, 3, 4 weeks' time, or even in 2 months' time. So that would involve multiple consultations, because you'll agree the first time and then there'll have to be another remission, let's say a greater percentage, and you'd have to agree again. So rather try and agree on a variable methodology now with the employees. So you say to them, if our income is X, then Y will be the remission. And you deal with it on that basis, so you won't have to come back and consult with the employees again. But over to you, Ian, just on the practicalities.
Yes, Maurice, and I'll just add to what you said. That can happen inside business rescue or outside business rescue. Section 189 and the Labour Relations Act applies exactly the same whether it's in business rescue or not, as you pointed out. So, yes. So the first, then we meet with the business rescue practitioner in a business rescue scenario, would meet with the employees or the employees' representatives after 10 days of being appointed. Typically, if the employees are represented by a trade union, then we'd meet with a trade union representative. If not, then we'll meet with an employee representative. We don't have to have a meeting with all the employees of the company. So yes, and obviously, it's, we're talking about people's livelihoods, and we're talking about their jobs and so on, and their abilities to feed their families. So it involves a lot of sensitivity around how it gets treated. And we have seen practical examples of where employees have had to be retrenched, and there simply isn't enough money in the company in order to pay the severance packages. And obviously that's not a very good situation to be in. It's a very desperate situation for the company to be in. But what Business Rescue does allow us to do is to delay the payment of those retrenchment packages or the severance packages for a certain amount of time. But obviously we go about realizing assets or generating income or whatever nature, so that we can pay those as soon as possible. But yes, we have had situations where you simply cannot pay the severance packages at that time, but we've had to pay them a few months later. And that was one thing that Business Rescue
yeah, but I think in that situation, it's important to mention that in that situation, if you cannot pay, the only alternative in the absence of an agreement is a liquidation. And the employees need to be informed of that.
Absolutely right, Maurice. Yeah.
Whilst I've got you, there's always, I'd say, or 99% of the time, there's an anxiety by the directors of the business that they're going to lose control. And they're resistant to Business Rescue because they want to retain the control. Can you comment on that, Jan?
Yes, absolutely. And, sadly, since the advent of Business Rescue and the first Business Rescues in 2011, Business Rescue practitioners haven't done the industry any favors, and they haven't done themselves any favors. Unfortunately, there's been many more bad Business Rescue stories than good Business Rescue stories. And everybody in the audience here, I'm sure, has heard some bad Business Rescue stories. That's why it's so critical. It's of paramount importance to the company to choose the right Business Rescue practitioner if the Business Rescue decision is taken. You need your Business Rescue practitioner ultimately having ultimate control of the board is obviously in a position where he may abuse his power. Therefore, you need the right individual. You need somebody with impeccable credentials and an impeccable track record. All the Business Rescue practitioners within the COBRA ecosystem have impeccable credentials and an impeccable track record.
Yeah, I sort of mentioned, like, for instance, an inexperienced Business Rescue practitioner may not send those notices out to the counterparties of contracts. And you may conceivably find yourself in a situation where your lease agreement gets cancelled, you're in Business Rescue, and you still get evicted. Why? Because your Business Rescue practitioner didn't know or was unaware that the contracts should be suspended. And on that note, always have a list of your creditors ready and contracts, so you can send that out to the counterparties of contracts that the Business Rescue practitioner can. Sorry, I interrupted you. Carry on.
No problem, Maurice. Absolutely. And that's a very good example from a legal perspective as to what might happen if you appoint the wrong Business Rescue practitioner. From a practical sort of management perspective, you can't have a Business Rescue practitioner who comes into the company, kicks the CEO out of his seat, and thinks he can just start running the company as the new CEO. We always express the opinion that we will never know as much about a company as the person who's been running it for the last 20 years or the last 10 years, as the case may be. We will never have the same relationships as you have with your suppliers and with your customers and with the public at large. So therefore, we are there to join, to sit with you, to hold your hand through the process, to make sure that the process is conducted properly, and to perhaps plug the gaps where you might be falling short, but in terms of the running of the company. But we are not there. We're there to work with you. We're not there to take over the running of the business, so to speak.
And by working with the directors, you come up with creative solutions. I recall last year you were assisting a Mexican restaurant in distress, and what you and the directors did was you decided to reinvent the menus, and as a result of that, the turnover went up. But that's because of the relationship you had. I mean, something like that you'd never ever be able to achieve as a Business Rescue practitioner.
Absolutely. There's multiple themes that we come across when we come across a distressed business for the first time. You know, sometimes it's a case of a company that the owner of the company is a great salesman, but he's not very good at operations and finance, you know, and kind of, so he's great at getting new contracts, but then, you know, his operations and finance are a complete mess, and he loses money for that reason. And that's why he's in financial distress. Sometimes we have exactly the opposite. We have companies that are very good at manufacturing a product, but they're terrible at marketing it and terrible at selling it. Sometimes we have a problem where it's just purely bad financial management, or even fraud at a senior level basis. So what we are there to do, and we bring to the party, what we bring to the party is a multidisciplinary business rescue and turnaround team. And we always talk about the skill set that is required, in our belief, to do business rescue and turnaround properly. And that skill set encompasses leadership, entrepreneurship, strategy, finance, legal, operations, deal structuring, and capital raising. And as a COBRA team, we've got all those skills at our core, and backed up by substantial capacity. And then when we need specialist skills in a particular industry, we've obviously, between our management team and between our various organizations in the COBRA initiative, have a huge, extensive network from which to draw those specialist skills. And that's enabled us in the past to operate across almost every industry that there is. So we will draw in those trusted specialist skills in order to assist in your specific business. In order
So now you've pulled in the expert skills, you've consulted with them, and you've put together a business rescue plan that has been successfully voted on. Tell us about the implementation, and what happens if the implementation fails? What does one do then if you realize that the plan was not good enough?
Well, the thing is and thanks, Marisa, we need to be very pragmatic. We're always very pragmatic at the outset, you know, and when we're preparing a business rescue plan, we've only got 25 days to do it from the time that we get involved. In that time, we've got to understand the business. We've got to understand as much of the intricacies of the business as possible. And, you know, in 25 days, as I've said before, you can never understand that business as well as the guys who've been running it for, you know, for ages. So what we put forward in the business rescue plan is how we understand, how we foresee the business rescue will roll out. Remember, as part of the business rescue plan, we've got to do 3-year financial projections. So those three, and that's what it is. It's a projection. And all of us know that, you know, projections very, very seldom, you know, play out. No matter what, whether it's a business plan or a, you know, or a cash flow projection that a company gives a bank, or a business rescue plan, it very seldom plays out exactly according to what the projection says. And as business rescue practitioners, we just put together that financial projection in good faith, and using all the knowledge that we've managed to glean for that company in the last 25 days. If after 6 months or after a year, the financial projection is sort of nowhere near what it should have been, in other words, the financial projection has seen creditors being paid within 6 months, or being paid X amount within 6 months, and now we think that they're only going to be paid within 12 months. We've got the option to go back to the creditors and say to the creditors, we're revising the business rescue plan, and essentially to call another meeting, like a Section 152 meeting where the plan is voted on, and allow the creditors to vote as to whether the business rescue should be continued under a revised forecast, under a revised plan, or whether the company should be liquidated.
And what do you generally find? I mean, at that point, do you find that the attitudes tend to shift towards a liquidation, or do the creditors still give it a shot?
Once again, Maurice, it comes down to whether there is actually a hope, or whether there is actually a reasonable prospect. You know, what you'll find is that the creditors, if the business rescue plan says that they should have been repaid 20% of their monies after 6 months, and they've only been paid 10%, then at least the guys have received something. So then they are much more comfortable to let it go on. And so then the attitude is, generally we find the attitude is quite good. You know, we've had some instances where we have managed to secure during the course of a business rescue that's been very litigious. In other words, where we've had to fight numerous court battles as part of the business rescue plan, effectively, where during those court battles we've won a substantial sort of advantage in terms of securing a right or something to that effect. Then even if the business rescue plan hasn't been carried out as it was initially forecast by the business rescue practitioner, the creditors will look very favorably upon this advantage that we've managed to secure as a result of the litigation. And they will use that as a basis to say, okay, we are happy for this business rescue to continue because you'll be able to exercise this right at X date, and that should see us getting getting the company back on its feet, or getting a better return than in liquidation. So the attitude is generally quite good, but in practice, creditors do run out of patience. There's not every business rescue is successful. Fortunately, we have a much higher success rate than the industry in general, but you can't save every patient, unfortunately. And what we do find in practice is when the successful business rescues are where management of the company really works with us, really goes out of their way to save this business, where their hearts are really in it, and they've had bad luck for whatever the case, for whatever reason might be, and they really work with us to make things work. The ones that are less successful are the ones where management simply sit back and say, okay, it's a business rescue practitioner's problem now, and they don't really put their heart and soul into fixing the businesses, and those ones are very difficult to fix. You can take a horse to water, but you can't make it drink, and unfortunately, some business owners just seem to kind of hope that we can make the problem go.
And then when it gets to that point, a liquidation becomes necessary, a conversion.
Yes.
And I just want to mention, and before I get there, we've got literally 8 minutes left, so if there are any questions, please post them now. As I said, as you saw, the questions give rise to fruitful debates and interesting topics. So what COBRA does is it's a pro bono service in relation to certain aspects which are pro bono regardless, and then there are certain aspects that are pro bono subject to a means test. And the pro bono services that COBRA does regardless, one of them relates to the conversion, the High Court application, converting a business rescue from a business rescue into a liquidation because it's failed. That conversion, so long as you've been in the ecosystem from the beginning, because you've got to give COBRA a chance to save your business. If you're part of COBRA from the beginning and it concludes in a liquidation, that liquidation is covered by Schindler's attorneys on a pro bono basis. That's a 30 to 50,000 Rand saving on that. Something else that COBRA does is we'll consult with your staff, HR advice, general advice, that's pro bono, to set up a Zoom meeting with us, and we'll give you one-on-one advice. It could be legal advice, it could be turnaround advice, it could be advice from IQ, it could even be advice as to whether we know anybody. Is there anybody in the ecosystem who can help? Because the network's getting bigger, bigger, and bigger. When it comes to the actual business rescue and the pro bono aspects of that, it's pro bono if we get you out of trouble and professional fees would have been a problem. So if we save you and the company is out of business rescue, but you only have a little cash to spare and the legal fees or the professional fees would have eaten into that, then it becomes pro bono, either entirely or there'll be a reduction to make sure that the business is rescued. But importantly, just going back to the pro bono services, regardless of the means test, the important one is set up a one-on-one with us so we can discuss your particular business and see what solutions we can come up with there, which includes, introducing you to potential PCF partners, or importantly, negotiating, getting us to negotiate with your creditors. And to that end, I'm going to pull up a letter, put it on the screen, that you'd put on your letterhead as being part of, once you're in the ecosystem, It's a letter to your creditors, which should be on the screen. Is it on the screen, guys? It is. And you'll see, so this actually goes onto your letterhead. The COBRA branding's there just so they can see it's real. You put it wherever you want it. But it says, we've joined the COBRA ecosystem. The War Room is a pro bono service to businesses that need urgent assistance. It's a partnership between IQ Business and the partners. Due to our business's financial distress by COVID, we're obliged to consider putting the company into business rescue in terms of Section 129. Remember, you're obliged to do this, which we've decided not to do due to the fact that we have joined the COBRA ecosystem. So bear in mind that in law, you have to give, whether you're in the COBRA ecosystem or not, you have to put business rescue to the vote if you're financially distressed, and you have to write to your creditors telling them why you have not put them into business rescue. COBRA is the reason, as Ian told us earlier. Please join the COBRA ecosystem. They'll assist you in mediating a financial arrangement between you and any company within the ecosystem. So it's to ensure our continued survival. That's your continued survival, because we'll marry up the cash flow requirements of your creditors and yourself. The idea is that you attempt to strike a balance, is what I'm saying, between creditor and debtor relationships so that everybody keeps their heads above water, regard being had to each business's cash flow requirements. They can immediately assist you in trying to strike an arrangement in relation to the indebtedness to which this notice relates. And then we pull them in and we send these notices to their creditors. Quite interestingly, we actually had this morning somebody who was right up there in the supply chain ladder, just below the banks, came to us and said, please assist us in getting our suppliers into the ecosystem, because we care about them and we want them in it, and then we'll negotiate with them and let them know that we're amenable to working with them and discounting and renegotiating payment terms. Just stop this share here.
Maurice,
I see that there, yeah.
I just want to ask you, if you do send that out, what happens if you don't strike a balance with the creditors and you're not able to actually come to an agreement to service the business needs going forward? And how long can you stay within that zone of trying to strike this balance before you have to reconsider going the business rescue route specifically?
Yeah, very good question. So I'll actually get Peter in to jump in, but once you're in the COBRA ecosystem, I would imagine that, bear in mind, you're not in business rescue at that point in time. So so long as you're in the ecosystem and the creditors are playing ball, you can keep out of business rescue. The moment the creditors don't and they start actually enforcing their rights, then you'd have to go into business rescue at that point to avoid them liquidating you. So the timing is really dependent on the creditor's attitude. But I don't know, Peter, do you want to comment on that?
Maurice, yeah, I mean, it's one of those interesting questions that, you know, from a practical point of view, you will know when you know, as daft as that sounds, because circumstances dictate. And as you rightly say, if it is threatening, or if a creditor is threatening, I mean, it sounds rather facetious to say, but what you've got to do is just beat the creditor up the steps to the court, because you've got to get your application in to SIPC. And as Ian said, under normal circumstances, not at the moment because SIPC is closed at the moment, but under normal circumstances, the mere sending the email, which is the forms, the resolution, and the affidavit, sworn affidavit, the company's immediately in rescue. So it's quite easy to beat a liquidation application. But the important thing there is to be close to your creditors. Communication is paramount, to make sure that they know where you are and you know where they are. And unfortunately, and it does happen, because very often by the time a company gets into this situation, relationships have been collapsed between suppliers, including the banks and the company. So from, you know, COBRA's point of view, it is quite critical that we make sure that we're in touch with those creditors to understand where they are. And we're an independent party, so the creditor will share stuff with us. And if there's any inkling that the creditor is about to move down the road of liquidation application, then rescue would be necessary. And then the question would still be, is rescue appropriate? Is liquidation not the answer? And, hopefully we're certainly hoping that most of these can be in a rescue situation, because liquidation helps nobody. But yeah, you're still going to make that assessment.
Great, thanks. Yeah, okay, sorry.
Liquidation application normally needs to be preceded by a section 345 letter coming from the creditor anyway. So that will give us a sufficient warning to be able to put a company into business rescue. And then, as Peter says, we still need to, at all stages, we need to consider whether liquidation is not a better alternative. But there's no incentive for us to liquidate the company, and it's normally 90% of the time it is possible for us to show a substantially better return in business rescue than creditors would get in the liquidation scenario.
And just very quickly on that,
audience. Sorry, I see it's 11 o'clock, but just to conclude, Peter, you were going to say something?
I was just saying a quick one. Ian and I are dealing with one at the moment where we've got the holding company, listed company in rescue. Its main trading, operating business has got 2 liquidation applications filed, and we're in negotiations with those creditors to have those creditors settled either immediately over time in order for them to withdraw their application so that we can still put it into rescue. If this thing doesn't go into, if this subsidiary doesn't go into rescue, the whole pack of cards will come down and significant number of people will lose their jobs.
Thanks everybody. To the audience, please email us at info@cobra.org.za, or you can email any one of us directly. You can email me on crespi@schindlers.co.za. The moment you're registered on the system, we call for a list of your creditors and we start making the calls, but obviously in consultation with you. Thanks to the panelists. Thanks, everyone.
Cheers.
Thank you.